offer and accepted. There's a question. There's a phone question. So I'll give you a few minutes to read through that question and give me your answer. At the end of the note from last night. Sorry? You others? Okay. I didn't take it away. So I'll give me a minute and I'll email it to you, those of you that don't have access to a computer, if you could read on somebody beside you. Just send it without any delay time, so hopefully you'll get it in. Yeah. It is in the note?
Oh, I printed out.
Yeah, I was sure it was in the note. Yeah. question is whether or not there's been offer and acceptance here. How would you assess this?
I'll take a stab at it and say no, since there's a counter offer, because there's a clear term, it's a clear deadline with respect to the payment.
Okay.
We discussed last time, so we probably know that could be important if there's a clear defined timeline with respect to payment. So even though they were able to reply the offer before the 9th, which is on the 8th as the day before, they clearly changed from the third to the original offer.
But is it a big deal, that change? Because they do say, we accept your offer.
Yeah, but the context.
But it says, but I attached something like a paper with.
Yeah, so a consent order, if you are unfamiliar with that, it's just a document that both parties would file with the court stating that we do not need the court date any longer, we have brought this matter to a close, and we seek you to sign off on this order. So I wouldn't read anything into the other side providing the form necessarily, other than expedience.
It kind of reminds me of the Stevenson case.
Sorry?
It reminds me of the Stevenson case. In terms of like
Stevenson and Jacques versus
yeah,
McLean.
in terms of like it might be a good, so they do accept the offer, but it could be just a mere inquiry in terms of changing the terms and conditions. It's similar to that case, they're just pretty much asking, we can just delay the payment process to April.
Right. So are you saying this is an offer and acceptance, or?
Well, I'm pretty much saying, I don't think it's counter offer. I'm saying it most likely might be an acceptance, but it could be just a mere inquiry in terms of just a delay of payment.
Okay. So is there acceptance though? If you're inquiring and you say, I accept everything you said, but I just modify this one thing. They're not asking, can we modify? They're sort of asking for forgiveness, if you will, instead of permission. Does that mean that they're inquiring and the other side can get back to them? So there is acceptance or not?
In my opinion, this is acceptance. We can apply the ratio in the Butler machine and Excel. The case means that the consent form is because it's not part of the contract, it's just for the formality to be filed with the court. So it means that.
So how are you using Butler? Because if you recall in Butler, the issue there was whose terms were signed off on last. And it was the buyer's terms because the seller signed the form, sent it back.
Yes, but attached another document explaining the.
Right,
Yes.
which is what they're,
So maybe the concept form here is analogous to the document attached to the
Right.
document case.
so you're saying that there is acceptance of what though?
Of the
What has been
a
accepted?
settlement offer by the.
Okay, but as was said by your colleague earlier, the payment date is changed, and his argument is that constitutes a counteroffer. So the question comes back to, is this a counteroffer or an inquiry?
I just want to, if I understand properly the context, that the original offer wanted to settle everything, including the payment, before the day of the hearing. And
The other side,
yes,
yeah.
the other side.
So the original offer
because if you
was well
put-
in advance.
Yes, obviously, if everything is settled and paid, then no need for the hearing of the court, right? I mean,
Right.
probably that's the logic, why is the day before the hearing? Now, if you change this date in the context,
Yeah.
it's not only just simply changing the date for 1 week, it's very substantial, because then you might need the hearing. You don't want to lose your hearing date. These
Okay,
things
so
are
just
not
explain
settled.
that. If the other side treats this as an acceptance, and the payment is due the day after the hearing, that hearing date has to be either postponed or
Yes.
something. If the consent order goes in, then it's agreed by both sides that this is binding. If there is no payment on that date, what does that mean? Just elaborating on what you're saying. So what's the repercussion if the other side doesn't pay on that day?
I mean, obviously, the agreement, if it's paid, then it's the whole,
Right, but
then
if
the
it
whole
isn't-
contract is already fulfilled. I mean, the agreement is fulfilled, the payment, right? It's pending in a way, if it's still not paid.
Right, so what would the other party have to do?
Enforce the order.
Then they have to force,
Enforce the order
I mean, it has
or
to
bring a
trust,
new claim?
trust that it will be paid and not to go to court.
Right, so,
But anyway, it expects the other party an extra trust.
okay, so in the litigation process, I see two issues here, or two strategies, just want to come to you. Sorry, just a minute, and then I'll come to you.
I'm sorry.
I think there are two things here. There's the extent of law, and then what we might call the strategy, the litigation strategy here. Now, I suggest that both kind of overlap. So if we're taking a practice perspective, I would say there's an added point of consideration. Why is the other side moving the date to that particular day
After the court.
after the trial date? So go ahead.
The way how I see it is that the offer was already accepted by saying that I accept your offer.
Was or was not, sir?
It was.
Okay.
So whatever comes next, it's something like that I don't think we could have any consideration in this scenario because the deal, like the offer has to be unequivocal, and it
Right.
was, and the party accepted the offer.
But doesn't the acceptance have to be unequivocal? So if, this is why I sort of started with the Roman law aspect. In Roman law, we have sort of these key terms that have to be used. And what I said was in the common law, you don't have to have key terms used. The question posed here is, what if you use one of those terms that have a lot of weight, like I accept? But after that, arguably you change the terms or amend them in some way. How do you deal with that? Is that an acceptance or not? And some people are saying acceptance, some people are saying no, and I'm interested in mining the reasoning on either side and hopefully coming to some sort of assessment based upon the substantive law.
Well, in my opinion, it does not amount to acceptance, and I would quote height and range, where
Right.
the acceptance has to mirror the offer.
So you treat this as a counteroffer.
I treat this as a counter offer.
Why not as an inquiry, as was said?
Because they were not asking, they did not suggest to pay this, they
Yeah.
just stated this, that's what we.
But do you have to ask? You know,
But the-
if I say, you know, here, let me put it this way. It's not nice what they did. It is kind of sneaky. But is it not free to the other side to say, wait a minute, I don't agree, you've amended the terms, you've changed everything. So in order for it to be an inquiry or a counteroffer, does it have to be a question posed?
Again, the language is potentially important because the words consideration and approval might indicate an inquiry. So it's arguably an inquiry if you want to use for your consideration and approval as a question.
Okay, Dayon, and then I'll come back.
Well, if I may just add one thing that I'm looking at, and I think that does have significance to your question. First of all, the answer is I accept your offer. And I attach a draft consent order.
Yeah.
A draft is generally a document that is open to any kind of reduction, especially with the errors, especially with the overlooks, especially with, it's a document for the court. So what I'm trying to say is that whether there is a contract, and the case escapes my mind right now, but we're looking at the language, we're looking at the conduct of the parties and the aim. So we have two litigants that are obviously settling on the same terms before the appeal, because nobody wants the judgment day, because it can go both ways, and
Right.
there's a huge risk.
Right.
So obviously, we are very clear that the aim of the settlement is to avoid the actual appeal.
Right.
And that's more than clear on both ends. One side is offering, the other one is accepting. However, there is just a draft consent given for consideration, which is obviously an inquiry if you want, or something that has to be identified further in order to finalize a paperwork with regards to the actual appeal. Because the Court of Appeal would like to see the order and say it's settled, thank you very much. What's the point of settling something a day after the hearing if the appeal court renders an oral decision on the day of the appeal, which may happen?
Well, they put aside the date, right?
Yeah.
So if the payment date is the day after, the idea would be that they would either postpone or cancel that hearing date. So the risk of the party agreeing to that is they've lost that date. And with it, arguably, any sort of leverage in terms of, because everybody works to a deadline, any sort of leverage in terms of getting a settlement. So the worry is, and that's why I was mining the point with Zika, what happens if the other side agrees to this and there is no payment? Then you have to go through what? You know, you have another proceeding that you have to initiate, and a court date is hard to come by, it's down the road and so on.
Well, you can enforce the order. If the order has been entered and issued, it's
Right.
a judgment. You go and enforce the judgment.
Okay. But
Same thing, what if the date was before the hearing and there was no payment?
well, then that's easier, right? Because then you show up and say, this guy's a bastard.
No, you don't have the order. You have nothing to enforce. You have to proceed with the appeal. Because there's no order. If you have an order, you have a judgment. And judgment is subject of the enforcement if it's not fulfilled in terms of the terms. So I would rather say that there is an agreement.
Okay.
I'm my modest opinion, of course,
Right.
based on what I'm reading. Maybe I'm just, trying to make it up, but
Yeah, I try to say that this case is distinguishable from the Stevenson case, so this is not inquiry. Because here, the parties use the very amicable term of I accept your offer. But in the Stevenson case, there's no such language used to bring to consummate the negotiation.
But isn't that sort of assessing it based on the form? Like they haven't asked a question, so it couldn't be an inquiry.
If they
So
don't-
Dayon, what I thought Dayon was going to say was, if you read the wording, I attach a draft consent order for your consideration and approval, implicitly, I'm offering you the opportunity to get back to me about this. So maybe within that, it could be an inquiry. I'm not saying either way, but as I said, that's where I thought Dayon was going to go.
It means we have to look at the entirety of the language used, because the most important part of the language is that I accept your offer. This
Well,
is
but
not-
that's the problem, isn't it? Like, if I'm on the other side, I'm going to do this because I want to cause problems. Because if I say accept, I'm betting that the other side is going to say, wait a minute, you accept, and then sort of gloss over the rest. And there are certain problems with that. And then,
This is not a substantive observation, but obviously litigation, and you seem to be interested in the practical consideration as well. Clearly, an appeal is not without, risk, so you can obviously buy the risk of the litigation by accepting these terms and converting it into a court order which you can then simply enforce. You save yourself the risk of, running that litigation and losing it. So, I mean, maybe that's not really relevant to deciding whether it's a counter offer, but I would certainly be saying to the client, let's take it,
well, I think it is relevant because if we take out all the stuff about the date about payment and so on, and just look at it as, is this an inquiry or counter offer? It seems debatable. The added element of changing the date of payment to the day after the date of the hearing suggests to me something more. There's something more at stake here. And so I would take a more cautious perspective and make sure that everything is clear as to what's being agreed to. So if I was representing, who made what? And Gibbs. If I'm representing Gibbs, I would show that to her and say, well, I think we should clarify things further and say, no, if you're accepting the payment date that we proposed, because we're not accepting the one you put forward. And the reason that I've given this question is it recalls, as people brought up, the idea of an inquiry. What is an inquiry? And coupled with that, just because someone says I accept doesn't necessarily mean they're not modifying or changing the parameters. If I wanted to mess around with someone, I would say I accept and then try to change things. There's nothing illegal about that. It's not nice, but that's not a problem.
Just for the English, for
Yep.
me, inquiry is automatic question. I mean, it means asking questions, no?
Yeah, well, and that's why I said,
I'm
they
not
are-
native speaker, so
Yeah.
I don't know if for native speaker,
But
inquiry
I think
doesn't mean automatic question.
regardless
It means
of-
I'm not clear of some things, can I ask?
yeah,
For me, it
see, I
means-
would think, whether, regardless of your proficiency or how confident you are in the language, if you're unsure, you make sure. So,
Not by asking, but stating.
yeah, well, like, if you're Gibbs' lawyer, you say, hold on. You said you accept. If you're accepting our offer. That's the offer being made.
So how can it be possibly inquiry?
Well, that's why I talked about Stevenson. How do we know that was an inquiry?
Because
But that was his question.
Yeah,
That was
question.
specific to the question.
Yeah, for me, that was
But
100%
again,
clear that it was-
see, I think you're looking at the form. A question was posed. And remember what I was talking about with what I thought DeYoung was going to say. I attached a consent order for your consideration and approval. Could that be an inquiry? There's no question mark. So, first of all, I'm saying don't be fooled by these magic terms like I accept and stop reading. Second, understand that in the common law, things are, in my understanding, probably a lot more valuable than you have in the civil law. there's a lot more room for argument and debate and interpretation. An inquiry is just one small example. Somebody had you have your hand up, now I'll come back to you.
For me, an acceptance, a true acceptance means the offerer can't say at that point, okay, no, we're not going to bother with this. That would constitute a breach. In this case, the offerer was able to say, okay, no, you have introduced new terms, and that for me makes it a contract offer.
Okay. There, and then there's,
In my view,
come back to you.
a significant term was the date of the payment. And that term, although the words were used, I accept your offer, that date was not accepted. So in effect, there wasn't an acceptance. Significant terms were not accepted. So that's a clear case that it's a counter-offer. It's not a question of inquiry. I'm not accepting your offer of that date.
And
Yeah, for me, the fact that they wait for the approval looks like a counter offer, because it seems that they wait that they have to approve the counter offer. So it's not that they just wait for an answer about an inquiry. I support that it's a counter offer.
so if we, the last 2 points.
I was thinking, the issue of the significance of the term, I was going to ask two more generic questions about materiality and severability. We haven't discussed materiality. I don't know if it's relevant in relation to offer and acceptance. Is it a significant / material term? And then the other issues, again, I keep thinking about advising a client to almost snatch at a settlement, really. So sever off the acceptance and, fight about the payment date at another time, because you could end up losing the settlement, if you know what I mean, the money settlement.
Yeah, but is it and I'm putting this up rhetorically, is it a settlement? If you just try to snap up an offer, in the common law, you're trying to snap something up, it's not enforceable. So I would question the strategy on that. Are you just delaying problems? And then the last one.
In my opinion, there's a clear statement here. The other party is accepting the offer clearly. Change of the date is a payment arrangement. So, like in Stevenson case, we should interpret this reply as an acceptance. We shouldn't consider it as a counter offer.
Okay. So,
just one question. I'm still having a big problem understanding why anyone would ask for the payment a day after the actual hearing. It's nonsensical. There is no purpose to it. It's an obvious error.
Maybe after the hearing date, we will
parties
find
are
the money.
settling to avoid the risk because there's going to be someone bringing both necks on the chopping block and one head would just roll. And they settled 90,000. So money has to be forked out before the hearing, so both of them avoid the risks of the hearing. Settling it up a day after the hearing is completely incoherent, doesn't have any logical ground on the basis of the actual deal. So in Butler Machine, Lord Denning said if the terms are irreconcilable, then you just ditch those terms if you can subvert them.
Yeah. The question is, can you sever them here? Okay.
Yeah, so I was going to say, so my rationale is temporary and potential factors, so we're looking at the substance. Even though they didn't pose a question, they pretty much did say it's a consent point for their consideration and approval.
Yeah.
And I think the problem that happened in Stevenson, when we talked about it yesterday, was where McLean misconstrued it as a counteroffer. And then based on your comments at the end of that case, pretty much you have to be aware of what's happening, and when we're not sure, it's better to just assume that it says required rather than counter offer.
Yeah, so here, let's take this as an exam question. How would you answer it? And I'm not giving an answer either way. What I'm saying is, all the responses that were given, you write that out. You explain why you see this as, for example, a counteroffer or an inquiry, and how that factors into your response to the question. So any law exam questions, generally, I think, do not give you one answer. It's usually going to be debatable as to which side things fall on. And the question is asking you to elaborate on how you reason your way through that. What factors are applied in the case law? How are you applying them? And how do you assess this scenario? So here, this wouldn't be an exam question. It's far too short. But if this were an issue, you outline what has been said. So, if you, as I said, if you think it's a counteroffer, explain that, but deal with the idea that it could be an inquiry and why you do not see it as an inquiry, and then the reverse. So I took this from an English case. They said it wasn't an offer and accepted this.
No.
Was it?
Yeah.
What they said, it was a counteroffer?
Yeah.
As all of us nearly said.
So the judge then got pissed off because they were so close and they couldn't resolve it before they
The
came.
judge doesn't care.
Well, our judges would be furious that something like that is brought to a hearing where parties are apart
See,
for a few days.
I would question whether or not it got that far. Like, I don't think Gibbs lawyers should, I think Gibbs lawyers should be certain respect about the facts.
They just want to put it outside.
So moving on to certainty. Gibbs and Lakeside. So we're into formation, and we have these four concepts of offer acceptance, we've just looked at, consideration and intention to create legal relations, which we are to look at. Within these four elements, there's this idea called certainty. And certainty asks the question, loosely phrased, is it clear what's being agreed to? So a good example are the English cases that we have at the start. Let's look at May and Butcher. What was the contract about here? Right. So it's after, yeah, after the First World War, the British Army has all these tents it doesn't need to use. Obviously, this is 1945. They needed them after all. And they're selling them on to May and Butcher. What is the agreement between the two parties?
The agreement, they agreed on the date that the price will be paid, the quantities, the available quantities, and they agreed that the delivery date will be determined later. But they didn't agree on the specific price.
Right.
Yeah, and later on, the army just confirm or accept that they will need the shipment on a certain day. But a couple months before that specific delivery date, so they said that we are not obliged with what we said, and there was no agreement. So May and Butcher just sued, and the issue was whether there is a contract and
And there wasn't.
Yeah, there wasn't.
Largely because
the-
price
there
was not
no price
stipulated.
in there, yes.
So just to be clear, even though the defendant is R, this isn't a criminal case. This is actually where May and Busher are suing the Crown.
Is or is not?
Is suing the Crown.
Is.
Yeah.
Yeah.
So Lord Buckmaster in the decision, and that actually is his name, writes an agreement between two parties to enter into an agreement in which some critical part of the contract matter is left undetermined is no contract at all. So Buckmaster is saying there are certain key elements to any contract. If you don't have them, there is no contract. It is void or uncertainty. But how do we explain Hillis and Arcus then? And I know Hillis comes before May and Busher, but I want to deal with it in contrast to May.
So, what I noticed in this case that the difference between the two cases, Hillis and the previous one, May and Butcher, that in Hillis the transaction was commercial transaction.
So is May and Busher.
Uh,
The Crown was acting as a commercial party.
But here they mentioned that in commercial settings, so there should be some flexibility in terms of like contract terms, and the court and the court may add some, and the court.
But here there was some.
The court can decide what is reasonable to fill the gaps.
Right.
There's some sort of performance here.
Okay.
There's no
For
performance
how
at
long
all.
was the contract for?
And
For 1 year it was going on.
no,
But-
for 1 year they already like fulfilled the terms of the contract perfectly.
Yeah.
And then later on there was some like breach of it. It's not a breach of the contract, but they tried to sell it
There were
to
problems
third-
in the
yeah,
second
third
year.
parties, but
So that's a key part.
Yeah, yeah.
This is a 1-year contract that's renewable. The first year goes well. Nothing happens. Problems arise in the second year. So one of the parties says, well, we had no contract after all. It's void for uncertainty. Why did the House of Lords say this was an enforceable contract?
Because they fulfilled the contract perfectly for a period of 1 year, so there was no problem. So both parties were intended to get into the contract terms.
So the
And,
terms can be
yeah.
seen from the fulfillment.
Okay.
Over 1 year, basically. You just have
So-
to see what they agreed in the first year.
What we have in contrast between May and Busher and Hillis is in May and Busher, it was an executory contract, what we call an executory contract, meaning it is to be executed. In Hillis, we have an executed contract.
Can you tell the difference between those two contracts? They, like,
And it's going to be executed, but it's not happening. There's no performance yet, and the other one was already performed.
So with Hillis, what we have is, again, coming back to that idea that I talked about in the start. These cases give us answers, but sometimes they give us more. They give us some insight into how the courts think through contracts. And I suggest Hillis is another one. In effect, the court is saying, well, you two performed as if there was a contract for a year. We are not going to now step in and say you had no contract. You were doing something. You were abiding by obligations for a year. So the courts will, if possible, maintain agreements. Because if we take it on the flip side, if they said there is no agreement, what happens during that first year? Were they operating without a contract? How do you deal with the parties obligations during that year. So the court says you were doing everything fine for you. You acted as if you had an agreement. So we're not going to step in and say this was void for uncertainty. Similarly, we have Foley and Classique coaches.
Can I just go back to the case before? The logic that there should be an agreement, otherwise it's complete uncertainty. And after the term, if there is an agreement already, couldn't they just have struck that one clause on the renewal option?
My understanding is that wasn't an option, the way the contract was constructed. So the idea has been floated already, we'll come to it. But sometimes you can sever clauses. So if you can sever a clause, you can maintain the whole contract. You just say, well, this clause is out. My understanding is in this case, the contract was written in a way that you couldn't sever the renewal for whatever reason. I don't think we're given a lot in the excerpt from the case, which means probably that it wasn't argued. So it's not that the courts refused to answer the question. Foley and Classique.
This is where the judge was unhappy with the counsel for the plaintiff, trying to repudiate a contract, pulling out some, short arguments.
Yeah.
The judge was truly unhappy for taking such an obnoxious position.
Yeah. But they did give it leave to appeal.
Probably to criticize.
Maybe. So, what were the facts here?
So there was an agreement that he would sell his land to D, but D has to purchase the fuel from D. So there was two kind of contract. The first one was conditional,
Right.
And the second one was supplemental to the former. So the issue here.
What was the price of the fuel?
The price of the fuel.
Decided final time.
Yeah, decided to acquire fuel.
At a price to be agreed by the parties in writing from time to time.
Yeah.
So here, you can say, well, isn't that uncertain? Militating against that is the fact that they performed the agreement for 3 years. So like in Hillis, we have an executed contract. This contract is for a lot longer than it was in Hillis. After 3 years, one party got tired of buying the fuel from the other and wanted it out. And the court said, we're not letting you get out of this. So as I said with Hillis, couple Foley with this, courts don't want parties coming to them saying, we want out of this contract, it's no longer convenient, or things like that. They will enforce what the parties agree to. So here, even though you can argue, well, in May and Butcher, they didn't have a price, why isn't it uncertain here? Because one, the parties had performed a contract for 3 years, or 1 year in Hillis. Two, they had a mechanism in place to determine the price. They didn't leave the price in any way of determining it open-ended. And an example of machinery for resolution is in the Sudbrook case. So there are 4 leases, the terms of which permitted the tenants an option to purchase the property at a price to be agreed by the valuers appointed by both parties. The lessees, so the people renting the property, exercise the option, but the lessors or the landlords refuse to appoint a value. So here we have an issue of you have a mechanism in place to determine the price, but one party is standing in the way of it being triggered. Does that mean then that the contract is void for uncertainty? What did the court find?
That it's not void, that the mechanism for agreeing on the price is secondary. So it's important that the parties chose, the parties already agreed on a certain method.
Okay. It's a bit more precise than that. Here, the court said, if the way the contract is constructed, the dispute resolution mechanism, let's call it, allows for the court to step in, then the court will. So if the mode for determining the value is subsidiary and non-essential to the contract, if the mode for determining price is essential, the court cannot step in. So in the excerpt in the textbook, you have portions of this case, and I'll read an aspect of it. When the option was exercised, there was constituted a complete contract for sale, and the clause should be construed as meaning that the price was to be a fair price. Where the machinery consists of valuers and an umpire, none of whom is named or identified, it is, in my opinion, unrealistic to regard it as an essential term. If it breaks down, there is no reason why the court should not substitute other machinery to carry out the main purpose of ascertaining the price in order the agreement may be carried out. So here, the court stepped in and determined objectively stepped into the case because the clause was non-essential. So the rule we get from this is the court can determine the objective content of the, in this case, the blank term, despite the fact that the third-party machinery was inoperative, if, 1, there is an objective criterion enabling the court to make the assessment, and 2, the parties have not impliedly rendered the third-party resolution crucial. So let's look at 1. There is an objective criterion enabling the court to make this assessment. What does this mean? How do you deal with this? Or how does the court make an objective assessment? So here we're dealing with a lease. How does the court make an objective assessment regarding the price, the new price of a lease?
Comparables. If you were today, if you're going to sell a house, or you can do a comparables with respect to other.
How do you bring that evidence in?
The court could appoint 2 or 3 individuals to appraise.
Right, so expert evidence.
That's right.
You bring in, it's not that the court makes it on their own, they rely upon the evidence of experts to determine roughly what is the market value of this property. But the second point, they can only do that if the wording of the dispute resolution mechanism does not prohibit it. Meaning that the means for determining the value was subsidiary and non-essential. And what the court tells us that means is that if they named an umpire or valuers, then it would have been more likely to have been essential. But because there were no names attached or anything like that, the mechanism was one that was subsidiary, and the court could step in, bring in expert valuers, the testimony of expert valuers, and assess the price. So what we have in these four cases is, starting with May and Butcher, that price is essential, but now we really see that price is not, fixing a price is not essential. In lieu of fixing a specific price, you can have an apparatus for such a thing. And that's quite common, because if you think of it, oftentimes contracts, like leases, are for several years, with an option for renewal. So the dispute resolution mechanism, or the valuation mechanism, allows the parties to avoid a dispute and send it to a neutral third party, thereby avoiding the argument about uncertainty. And things have become more sophisticated, so we have the Sale of Goods Act in Ontario. Section 9, the price in a contract of sale may be fixed by the contractor or may be left to be fixed. The statute says you can create a mechanism for valuation. If there is no mechanism, then the buyer can pay a reasonable price. And speaking directly to what we looked at in Sudbrook, you have section 10, subsection 2, subsection 2, where the third party is prevented from making the valuation by the fault of the seller or buyer. The party not in fault may maintain an action for damages against the party in fault. So in Sudbrook, another aspect of the case was the landlord, for whatever reason, didn't want to, it seems, rent to that tenant any longer, and was blocking the process for valuation. I'll just briefly note Nickling and Simmons. We talked a bit about severance of a clause. Is this the one? Yeah. So if somebody, this is almost like somebody calls you up and you don't have your standard form with you. And you say, okay, well, I agree to do this, but the usual terms apply. And the court said, well, that phrase is meaningless here. You can't rely on that. But there's still a contract. We can sever that clause. So there still was an agreement. A Canadian case, Calvin Consolidated Oil versus Manning, I think is an interesting case. And the impugned provision was this, and I'm just reading from the excerpt from the textbook. It is agreed that the terms of the formal agreement are to be subject to our mutual agreement, and if we are unable to agree, the terms of such agreement are to be settled for us by arbitration by a single arbitrator pursuant to the Arbitration Act of the Province of Alberta. So here we have two parties that entered into an agreement to, was it purchase land? And develop land. So if you think of it, two people get together and they're going to buy land. They're not sure what they're going to do with it, but they're going to buy the land. And they anticipate, well, maybe down the road, we'll both want to do something different. How do we deal with that? Well, we'll use this clause that I read out. Is that too uncertain to be a contract between the parties? is that we want flexibility for long-term arrangements in commercial matters, but is this just too far? Is this too vague? In that the parties will buy the land, but they don't know what they want to do with it.
But there is a machinery, the arbitration, you know, to decide the contract.
Sure,
If there is a dispute.
but is that enough? We don't have an executed versus executory situation here.
But it's a long-term contract, and situations, I mean, you cannot see every single situation which might cause
Okay.
differences between the parties. You cannot decide everything years ahead.
Yep.
Is it similar to the last case where you had an arbiter? They agreed in the contract?
Yeah, but in the last case,
There was no need as well, so there was no specific arbiter given to the court.
right, but it was a bit more precise as to what the arbitrator was supposed to do, resolve the price. Here, the arbitrator is supposed to come in and she's supposed to say, this is how you should develop the land, which is quite different. So here, you have the decision in the case, in the textbook. I'll just read an excerpt from it. Mr. Justice Judson writes, there is every reason, therefore, why the parties here introduce an arbitration clause into their agreement to deal with this particular point. The consequences would be that contracting parties in the position of Calvin and Manning, who do not know what their ultimate intentions may be if they retain the property, must provide in detail for contingency that may never arise unless they wish to run the risk of having the rest of their contractual efforts invalidated and declared unenforceable. So, as I said with Phillips and then Foley, Manning gives us some further insight into how courts approach contracts, in this case, the idea of certainty. And in particular, in a commercial setting, courts are, let's say, more flexible or more lenient in terms of precision of what's going to happen, and in particular, what disputes or what an arbitrator is empowered to do. Because, for the reasons I just read out, commercial parties cannot necessarily anticipate everything during the life of especially a long-term contract. So they do this in order to provide for a means of resolving potential disputes. It may never be a dispute. But this sort of forethought does not invalidate the contract as a whole through uncertainty. So it's a way for, put in other words, for prudent business people to arrange their affairs. Yeah.
Following from your last statement, how far down the continuum one has to determine whether this is just an agreement to agree versus a mechanism? Ultimately, if the mechanism is not set up,
right,
or at least the formula for the mechanism, you're still agreeing to agree on something that is not there yet. So is this a question of purely business transaction, the reality?
Well, we know from, and just looking ahead, the Manpar case, an agreement to agree is unenforceable. That is not certain, sufficiently certain. Here, so then the question would be, what's the difference between Manpar and Calvin? The difference is there's more than just an agreement to agree in Calvin. They agree to purchase the land. They're not sure precisely what they're going to do with it. But there is agreement to do something. First of all, to buy the land, and then to further develop it. With an agreement to agree, you don't even have that first agreement to purchase the land. you agree to agree at some future point. But to what are you agreeing? What are the terms to that agreement? So in Manning, there's something more precise. There's more certainty as to what the contract is about. In Manpar, there isn't. It's just an agreement to agree. And it wanders into the territory of good faith, which the common law has generally not liked. And certainly even now, while we have a duty or an obligation of good faith performance of a contract, there remains no obligation to negotiate in good faith. And Manpar will be taking us into that path of an obligation to negotiate in good faith, which the court wanted to avoid. So what I'm going to do is, there should be a question, I'm sure there's a question, at the end of the certainty section, giving you a clause. And I've asked, is this clause certain, or something like that. So what we'll do is we'll take the break until about 35:40, 7:35, 7:40. We'll pick up with that question and work through based on what we've discussed with certainty. Clause uncertain or not?
I think it's like certain now.
What do you mean?
Like, because there's maybe not like 100% certainty. However, this clause provided some mechanism to solve or to explain the terms, which the first part, like to enter a negotiation in case they didn't reach an agreement, they gonna go to arbitration.
Okay.
Yeah,
So you're saying there's a mechanism in place for resolving a dispute?
A dispute,
Okay.
explaining the term of the contract.
How is this clause triggered?
After September, no.
By major physical financial change.
After negotiation.
No. After major physical or financial change.
Oh, yeah.
So what does that mean? Is that too vague?
It's vague. It's vague.
No, it's not vague. It's because it says major physical or financial change. The
What
word
does that
says-
mean?
What does that mean? That's the question.
You measure, because it's...
Yeah, my friends, I have a hangover and it's major for me.
Any
And also
major
it
physical.
says that, or at any time after the 5th day of
15th.
September,
Yeah.
2017.
So it would seem as though maybe this is open-ended.
Yeah, I see, of course, there's vagueness in it, it's like to determine exactly what the major physical or financial change in these circumstances.
Right.
That's why they have the mechanism in order to solve that
Okay.
issue.
So let's relate it to the cases we've looked at, applying those cases. How would you apply them here?
You have this price issue, the prices.
Right, but we don't have that here. But maybe by analogy of the reasoning?
Yeah, I mean, the idea that things can change,
Yeah.
I mean, it's a long-term contract. I mean,
Between commercial parties.
Between commercial parties, supposedly they want to continue the relationship, but But things are changing, so conditions are changing in the contract. So
Okay.
instead of saying that, because the other option is what? That every time we make for 3 years, and then you start again a negotiation, and you make a new contract. So instead of this, they make it open-ended, and time to time, they open for negotiations.
Belka?
So pretty much, it does say that there's a clause that stipulates that you refer to arbitrator who's an expert, so that arbitrator can essentially constitute what major physical changes might be predicated on their expertise.
Is that what the arbitrator does though?
Well, most of the time.
Determine whether or not a major physical or financial change has occurred. I thought it was, once that's triggered, the parties shall amend the terms, and if they can't agree, then the arbitrator steps in.
Yes.
So the arbitrator doesn't determine the triggering event, or whether the circumstances have been triggered. The parties determine that.
I think I have an, I'm thinking of something. If this particular, commercial transaction is something that is, common knowledge to people who are in this particular area of business, then the term major physical or financial, changes could be ascertained somehow.
Maybe there's an industry understanding
Exactly.
of the phrase.
Exactly.
Yes.
Other than that, I think it's just too vague.
Okay, so let's assume there isn't an industry understanding
Okay.
here, and it's just the language as it is. Nobody's mentioned the date, the year. What happened in that year? Around this time, actually.
Oh, global financial crisis.
Yeah, the Great Recession was taking hold. At that time, we didn't know what it was, but looking back, we now know. So if you have a clause like this that says, a major financial change in circumstances affecting the operations, would the Great Recession, as it's called, constitute such a triggering event?
Yes.
Yes, probably.
We can say looking back, but put yourselves in the position of the lawyers at the time. What would the arguments be? Yeah.
I think no, because I see the same circumstances, and as we have in Tourist versus Argus, they say that the First World War is not doesn't have any influence in this case, and they didn't consider it a fact.
Okay.
So,
But I would say it's a bit different here because the clause says, clause 22 can be triggered by a major, in what we're talking about, financial change in circumstances. So if in Hillis it said a major global catastrophe, maybe then it would factor in. I would say that in Hillis it wasn't a factor because of the construction of the contract. But here we actually have a contract that invites consideration of external circumstances.
but then they assess if it's a major at the time.
Well, and that's what I'm asking, right? So if you're in the midst of things in 2007, the fall of 2007, what are, as I've said before, a good way of looking at things is to, even if you're representing one side, anticipate what the other side will argue. So what are the competing arguments here regarding this being a major financial change? Edward.
Like, the way I may argue is like, what do they mean by major physical or financial change? That's anything that's unforeseeable, yeah, that's gonna constitute a major financial or physical.
So on one side, a party saying it wasn't triggered, they can say, well, this isn't anything unforeseen. We've had recessions before. There are fluctuations in the markets continually. Just so fluctuation is insufficient to trigger.
Exactly, but that's foreseeable in the market, in the
Right.
financial market, like fluctuation and change in rates to a certain degree.
Right.
So that should be like, for example, if I'm gonna sign like a contract for mortgage or with the bank.
Yeah.
So this change in rates, okay, to a certain degree,
Yeah.
is foreseeable. So the bank gonna change the rate automatically.
Right, but what's the argument to say that this is a major financial change?
I think it's not so broad because they are referring specifically to something that affects the operation of this company.
Okay.
So when you're not referring only to a physical or financial change in general, I think you have the opportunity to give some evidence of how that affected that company.
Yeah, okay, so it's not anything that's happening globally.
Yeah,
It may be things happening globally, but affecting the plant.
yeah.
Okay.
Yeah, we are going to look at the ability to perform the contract. If the performance of the contract is impossible, at that point it's a major change. But if the performance of the contract is possible within the change, it's not going to affect.
Okay, so my question remains though, how do we make the argument that this is a major financial change? Go ahead.
I can offer theory of statistic analysis that if we see that those green factors fit neatly into a normal distribution order, and then we can say that because the deviation is more than one standard deviation, so it means that this kind of probability for this event to happen is less than 5%, we can say that this is unusual.
How do we define a recession? This may be outside of your area. But what's the definition of a recession?
3-month periods of negative growth.
2 consecutive quarters of negative growth. So arguably, that's a low threshold.
Yeah. But if it is impose a lot of burdens in one the party of the contract, may be qualified.
Yep.
But if it is impose a lot of burden that it is impossible for him to perform the contract, at that point you can talk about it.
Yeah, but I'll just amend what you're saying a bit. There's a concept called frustration or force majeure. And we aren't quite at that point here. This clause is saying, let's not wait until frustration. If we see something major happening, physical or financial, this clause says we can step in and amend things so that it doesn't get to the point that it's so bad. So we're not dealing with the impossibility of performing, we're saying things are going wrong in some way that's directly affecting the operations. And what I'm adding here is put yourselves in the situation of the lawyers at the time of the, what we now call Great Recession, just at the start. Edward, you have your hand up.
Yeah, I was gonna ask about the wording of the clause, like, does it affect the clause, like saying the operation of Tata's works at whatever is their name? Okay, so that doesn't indicate that Tata's plays a role in deciding what is a major physical or financial change?
Well, the parties are the ones that agree that it's been triggered. Right, so Tata will be one party. So the idea is you have 2 commercial parties. And as I said, you have a hint that something's going wrong globally. This seems to be something a bit bigger than 2 consecutive periods of negative growth. I forget the timeline about things, like when Lehman Brothers went. I think it's a bit later than September of 2007.
2008.
Yeah. But things were beginning to go quite poorly in the fall of 2007. So how do you make, my question is for our purposes, how do you make that argument that this clause has been triggered? So it was said maybe statistical analysis is one thing.
Loss of profit.
Yeah, but this is the thing. I would say it has to be something major. Loss of profit, like a recession, a regular recession, if we can call it that, is something that happens. You have normal fluctuations. A recession, a generic recession, I don't think could trigger this clause. Because they're saying it has to be something major, physical, or financial.
Well, you know, I appreciate you probably know the case, but just pure reading of this little clause doesn't lead me to conclude that in absence of any objective standard of what's major physical or financial change, this could have been just a purely subjective position of contractual parties by which the parties would be free to elect at their discretion to say, look, we don't want to operate on these terms anymore, and you know, either of them can do.
Well, why not? Because the idea of the contract is parties can agree on whatever they want if they agree. So here, if they agree financially things are bad, we need to rearrange our affairs, they can do that. Sorry. Yenny, sorry.
So you asked what would the argument be, and I'm trying to think if, let's say, this clause shows up on my desk, do I move beyond this phrase in the event of any such an uncertain to me phrase to get into, okay, what would constitute a major physical, like, do I move from there? That's my question to you.
Yeah, and what I'm saying is,
How can you make it more certain? How can you make it more certain?
yeah, well that, but also, I think, whenever we have, how to put it coherently, I think this clause is a very good example of something that happens in fairly regularly in commercial transactions. How is a clause triggered? Commercial or any sort of contractual reaction. How you'll have this long contract, and but the only thing at issue is here. Added to that, if you look back now, if a lawyer at the time said, well, I think that's too vague, I'm going to pass it on, somebody's upset in a year's time. Because by that time you have Lehman Brothers going, the British banks cutting off Lehman's money, which then triggers everybody trying to get their money out, and AIG eventually be in a precarious position. So my point is, in the moment you can say, doesn't look like much. But a year later, it's a hell of a big thing. So it is hard, but we're paid, I hope, handsomely to deal with those things. This is what we're called upon to do. Now I forget who had their hand. Yeah, and then I'll be.
Okay, I think that similar situation is that when there's a merger and acquisition transactions, usually there will be within a MAC clause with a material adverse change. So actually, there are a lot of present cases litigated on this, on a line of cases on this matter. So whether we can draw a analogy to these cases and say that there could be some kind of quantity threshold, say that if the, because say that affect the operation of the company, so it means that maybe the company's profit drop, maybe marginal profit drop maybe by more than 10%, then we can say that this is prima facie case that this is.
Yeah, but major physical or financial change doesn't say negative or positive at all. It's completely weak.
But if it's positive, then you don't have the incentive to.
But
Maybe
this
you
is where
don't. Why would you assume that there is incentive if you're growing, you're getting bigger, that you're still interested to keep the contract on the same terms? Why?
Because if it's, whether it's negative or positive, will affect the parties differently. It means that if it's positive, then maybe one party will have more incentive to negotiate than another party. So
I think we have the cases that come in here. So Ebra and then Malcolm.
Yeah, I think there's no correct answer to this question because it depends mainly on the side that you are representing. Okay, for example, if you are presenting the party that's claiming that there's a major physical, you are not gonna say, look, there's a major physical or financial change. You're gonna like attach some statistics, some expert opinion, okay? In that case, and claim, yeah, we cannot continue with it, so we must like renegotiate or go to arbitration. And the other party, because he's still benefiting from the contract, definitely gonna say, no, that's not a major physical. So it's mainly depends what party.
I understand that, and that's why I said though, I'll put it to you this way. I would say all law exams operate the same way. The problem questions put you in the scenario of a lawyer where the client first comes to you with the problem. Not when you're in court. Because the law exams don't give you all the facts in their entirety. There are some things that are vague or you're uncertain about. And law exams are written in this way because that's really where you test your knowledge. When a client comes in and says, this is my problem, what can I do? And they don't want to wait around for half the day while you go research it. You have to know, generally speaking, what's happening at this point. So that's why I'm saying, how do you address it? You take the arguments for and against what you're saying. But at the moment that you are advising the client, you're giving them an objective assessment of the laws applied to their facts. And they want to know, should I pursue this or not? Once you're in court, you know your position and you have to argue it. But at the objective assessment of what's going on, you have to understand both sides, if you will. And that's where the law exam is, and that's why I'm going through this exercise with you. Balcar.
We kind of addressed it, so I'm trying to find the case right now, but basically when we talk about objective assessment and then bringing in expert evidence too, because if you are that party there that is trying to get attention that this clause is valid and there has been a major change in fiscal circumstances, then like that you mentioned too earlier with like a recession and whatnot, you'll see like a crazy deviation in terms of like, even though like a common recession does show fluctuation, you can bring in expert evidence within that field that shows that pretty much we are having the Lehman Brothers situation or Barclays Bank situation too, where pretty much we've lost public confidence. This money is being pulled out of these like public companies and pretty much is hindering their ability to operate on a day-to-day basis or up to the extent of insolvency. Right, so when you're trying to do that, so the onus is on the. So I was put the onus on the person who's trying to claim to enforce that clause, and they can bring in the expert evidence within that.
Yeah. So here, so this is an actual case, an English case, as you can tell from the Welsh name of the court. called Associated British Ports and Tata Steel. And the court said this was certain, this clause, and it was triggered. What's interesting to me about this case is it was only decided in 2017. So the parties spent 10 years complaining to each other about whether or not, in this case, a major financial change had transpired.
I found it on Google, and is it not because notice was only given in 2016 and not related to the financial crisis? I think, for what it's worth, I think notice was given due to the cost of
well, Tata
import.
has now gotten out of this port. It's no longer operating there.
Except, I mean, I think they only gave notice because the cost of imports and exports from China and to Europe, etc., were growing up.
Yeah, but for our purposes, it was still...
That would still be any good, that would be there.
No, but the clause was certain.
I accept that,
Yeah.
yes.
And I'm focusing on how do you know what arguably, as some people, their first reaction was, what is arguably a vague phrase. How do you assess that in the moment? With the backdrop now that we have of the Great Recession, how do you know when you're at the start of it, when there's a Great Recession, which subsequently constitutes a major financial change? I was amending things a bit along those lines.
I accept that, yes.
But the clause comes from this case, and the court said that the clause was certain.
And what was the ratio?
Sorry?
What was the ratio? What did?
I'll just read. So this is paragraph 44 of the decision. I consider that the trigger phrase used in clause 22 is sufficiently certain to create a binding obligation on the port and Tata to refer a dispute to arbitration. The wording and context of the clause point to the kinds of changes that can trigger the right to seek a revision of the license. And then carrying on, I would say that the wording does not leave the scope of the trigger entirely open-ended. There must not only be a major physical or financial change in circumstances, but also one that affects the operation of Tidal Harbor or of Tata's nearby steel plants. So just on that point. So, yeah.
Sorry, what's the name of the case again? Sorry.
Associated British Ports versus Tata Steel. You could probably cut and paste a portion of the clause and just find the case too. So again, just to consolidate the point, I'm giving you this clause and going through this exercise to deepen our understanding and investigation of the concept of certainty. And also to draw out, and in some ways mimic, what you would do with an exam. Thinking about the different arguments that are available. The thing that was missing from our discussion, largely, was applying the cases that we've done. So there is an expectation that you wouldn't just be making up arguments, but you'd have authority for your arguments from the cases you've studied. And just to sort of give a background to that, my expectation, and I've noted this to some people, is that you know the cases I pointed out in the notes. I do that because everybody, in my opinion, starts from the same basis. And it allows people to show what they can do with the same base material. So here, there'd be an expectation that if this clause was an exam question, you'd be applying the cases that we've looked at in the previous times made to develop your argument.
It seems to me as if the ratio just simply reiterates the statements in the case. I mean, what's the advancement in the law so far as this case is concerned?
I don't think there's necessarily an advancement in the law like what we had with Hillis and Foley. But what I suggest is, for our purposes in particular, that case is quite useful to delve into a problem question around the idea of certainty. How do we apply these terms with a specific clause?
There's a useful comment by one of the law firms about the principles. Just for me, what was interesting is when we read these old cases, you think, what relevance will they ever have here in 2019? And this is actually a 2017 judgment. And the case comment says, one, Individual will seek to uphold renegotiation of price review clauses in long-term contracts where performance is commenced, which is one of the principles in the old cases.
Yeah.
Two, it will be assisted in doing so if the clause contains objective criteria for the trigger and or the renegotiation objective, which is another principle. So, I mean, it's only a 2-year-old case and it's pulling out kind of 2 old people.
Yeah, so to elaborate on the point that was made, these cases may seem old, but they're foundational cases. If you go into a law firm, especially what they call here a Seven Sisters firm, one of the Bay Street firms, I would bet they expect you to know these cases. That this would just be like English. You know the language. So that's why I'm saying, again, to repeat, that law exams put you in the scenario of a client coming to you first with their problem, not when you're litigating in court. I think that's a common misconception, that law exams are about when you're in court. It's not. Law exams are asking, how do you interpret the law? And that's very different from advocacy. Interpretation of the law is an important part of advocacy that sometimes I think is overlooked. So understanding the competing arguments. Any other questions? Yeah.
So the decision was after 10 years. So we know if a clause is certain or not, but only after knowing the full financial consequences of a certain.
Well, as was said,
So at the
I
time-
amended the facts a bit. So the clause wasn't triggered until much later. I amended the facts to say, what if you're a lawyer in September of 2007, and you have this clause that's come from a client, and the client says, I think I can trigger this. How do you address it at that time? The
Less
lethargy.
information available.
Sorry?
I think because you're in the beginning of a recession, and I think economy is also unpredictable, and it's like you cannot be very confident on.
I would suggest to you, you're never confident until you win the case. And then you don't know how you won. So, uncertainty is an unfortunate byproduct.
There's more information about the history of the case, the procedure history of the case, whether there's first instance decision that is actually decided on the other side, and because the appeal court has the benefit of hindsight, and the reverse or...
But I think that actually plays into it, because by the time this is a trial level decision, by the time the court gets its hands on it, things have sucked for a long time, to put it mildly. As an aside, if you haven't looked into this, I would really, really recommend, there's a book called Too Big to Fail. Take a look at that. It's also a movie, if you just want to look at it in 2 hours. But it traces the history of what has transpired in remarkable detail. And I would say that for us practicing law now, that kind of information is quite useful, especially in a commercial setting.
What's the name of
Too Big to Fail.
Is it on Netflix?
Yeah, I think it is. but you can probably get it free on one of those other sites. So we'll move on to intention. This is the third aspect of formation of contract. And I would say probably the easiest and one that we don't really need to spend a lot of time on. Intention to create legal relations really comes down to, you can say, well, did the parties intend to enter into a contract? That's what we're generally asking. But the way the courts have dealt with this is that they've...
Basically between the business and the
Yeah. So the domestic and social versus commercial settings. And there's a presumption in each of those settings. In the domestic, there's a presumption that the parties did not intend to enter into a contract. And in the commercial setting, there's a presumption that they did. And I suggest when we look at the domestic setting, the institution of marriage does not come out looking very good. Because essentially we have these, what become divorce cases, like Balfour and Balfour, where the courts say, promises that you make when you're in a happy marriage are not binding. But once you make the decision, that's with the merit case, once you make the decision to divorce, then things get serious. And you mean what you say. And the phrase that the court uses is living in amity.
What does it mean?
Sorry?
What does it mean?
Living in amity, a happy marriage is the way I look at it. So everything's going well. So in Balfour and Balfour, the husband was going to Sri Lanka, and he said, I'm going to pay you, my wife, £30 a month. Keep in mind, this is early 1900s. And then they live apart for so long that they eventually decide to divorce. And she says, well, you promised to pay me £30 a month. And the Court of Appeal says, he did say that, but it was at a time that the marriage was going well. They were living in amity.
From amicus.
Yeah. But then Merrick says, things get real once you decide to divorce. And you mean exactly what you say. So that's sort of a brief overview of the social arrangements. There's sort of a, I can say funny now because I'm not a party to it, Jones and Patabatten case, where a mother wants her daughter to leave her job in Washington and study to become a barrister in England. And put politely, I guess, the daughter is not cut out for law. She keeps failing the exams, and the mother cuts her off because she keeps failing. It's an entertaining case. But I think Merritt and Balfour and Balfour give us the idea. Commercial arrangements, they are binding. I don't think there's anything too controversial about that. The only nuance to it, I think, would be, where did the case go? Would be where you enter into a business with family members. Then you'd have to show that there was an intention to be bound. For example, a partnership amongst sisters to create a company, to be binding contract. I'll move on to letters of comfort now. Have you ever heard of a letter of comfort?
Yes.
What is a letter of comfort?
It's not when somebody dies.
No.
How
There's no comfort in that.
Oh, it depends, you know.
I don't want to go there. Just like the comment on marriage, I don't want to delve.
You don't need to divorce, you know?
The way I encountered letters of comfort was where a parent company promised to secure the obligations of the subsidiary.
Yeah, like Klein Work and Benson. So a letter of comfort is provided by a parent company, as you said, saying that they will underwrite their subsidiary, meaning they'll cover the debts. But that's not necessarily always what is contained in a letter of comfort. I would say letters of comfort are actually letters of discomfort. And Kleinworth Benson shows why. And just trying to remember, what was the, yeah. So, I don't know, did I give you the summary for this case?
Yeah.
So, did I highlight point 3? No. Okay, so point 3 in the smaller writing, this was part of the letter of comfort that was provided. It is our policy to ensure that the business of MMC Metals is at all times in a position to meet its liabilities to you under the above arrangements. My question to you is that binding? Is there an intention to be bound in point 3?
The way they spell it, it is our policy. It's as if it's some kind of internal matter within the parent company. So they probably have some internal rules that they should oversee the operations of the subsidiaries. So it doesn't sound as if it's a legal undertaking against the recipient of the letter of comfort.
The way I always think of this letter is, if your partner comes home late at night and you say, "Did you just cheat on me?" And the partner says, "It is my policy not to cheat on you."
To ensure not to cheat.
What is your immediate thought?
He has a medical
You have the divorce lawyer on speed dial. So I put it in that context because I think there's no greater assurance in this letter than there would be in that situation. Telling me it's your policy means nothing. I don't care about your policies. There's nothing, and the court found, there's nothing binding the party to cover the subsidiary's debts. So that's why I call this a letter of discomfort. There's no comfort drawn. And I don't see why anybody, including in this case, would take any sort of comfort from it.
Is it from guarantee?
Sorry?
Is it different from a guarantee?
From indemnity?
The guarantee.
A guarantee? Yet a letter of comfort is not a guarantee. It's supposed to make people think you're guaranteeing without actually being binding. Yes.
Yeah, isn't it similar to the one case we discussed earlier that this clause doesn't mean anything, like, for example, the clause usual condition.
Yeah.
Isn't it similar that it doesn't mean anything?
Yeah. That when you get down to it, there's nothing binding in this phrase, in a letter of comfort.
So what the judge gave judgment for the plaintiff.
Yeah, exactly. That's what I wanted to ask.
Since the judge gave judgment for the plaintiff's only claim for breach of contract.
Probably it's an error.
Is it?
Yeah.
Judgment, dismissed the judgment.
No promise was made in the letter, is what I have. Do you not have that?
No,
just have the
what I have
judgment
here is
of
this
the
one.
Okay.
The judge
so-
gives judgment for the plaintiff from the
No, so-
breach of contract.
The court overturned the trial level decision, no promise was made in the letter.
That part is missing.
Yeah.
That part is missing.
Was it, maybe you've given, this is an appeal, so perhaps there's a missing bit about. the-
Maybe I gave you only the trial level.
Yes,
then.
because this is house.
Oh, yeah, no, so I see that now. The judge gave judgment for the plaintiffs, but that's in the facts. Then you have the issue in the rule. So the trial level.
I think we perhaps have the draft notes, because we don't have the issue in the rule notes.
Yeah, I think this case is in the textbook.
No, I'm sure it
That
is.
was, so when, I was trying to help because I thought the facts were a bit complicated. So instead of trying to decipher what was happening, I gave you the facts and then you fill in the rest. So the Court of Appeals said there was no promise made in the letter.
Thank you.
And in particular, they said at 382, M had specifically acted so as not to give a guarantee, instead giving a comfort letter. The plaintiffs responded that this was satisfactory, but a higher rate would need to be imposed for it to be binding. Yeah.
I just want to be clear on whether, is it certain that comfort letters are not binding, or is it just in this case? Because they are today in the commercial world where comfort letters have very precise language and certainty of terms,
Yeah.
spelling out assurances from holding companies, for example.
Yeah.
So I just want to be clear, are we saying blanketly they are not binding?
It depends on the wording.
Okay.
But what I say as a blanket statement, there should be little comfort taken from a letter of comfort. It should be something binding. So you should be able to rely upon it.
I think the caveat to that is that once the language is precise and the terms are certain, then a comfort letter could be held in a court of law.
I would say Kleinworth was the letter, the words were precise and things were certain. They weren't covering it.
Yeah, but I'm saying today, I'm a chartered accountant, I deal with these things on a
Yeah.
regular basis, and lots of comfort letter are taken rather seriously and dealt with in arbitration, for example, where they are held to being binding.
Looking at Kleinworth as just one example, I find there's cause to be skeptical of it, and that's the point that I'm making here. That you want to be very careful about the word. Just like the problem question you started off with. Somebody writing, I accept your offer, and then going ahead to arguably amend it. That's something that you have to watch for.
Also, I think comfort letter may run into the issue of bad faith if you're offering these things.
I would say that bad faith is a nebulous concept in Canadian law. We don't really have a definition of bad faith. We have a concept of good faith that's developing. But I would say if you read the cases after Bazin, the Supreme Court decision in 2014, fewer cases are giving effect to that precedent. They're distinguishing it largely. So in terms of a litigation strategy, I would be hesitant to rely upon the concept of bad faith as my primary argument. I'd want to have something more substantial.
Is it possible to argue that in this case that even the offer letter is not product, will not ground the contract, can be still ground some cause of action or tort? I say that because
tort how?
you say that because it's our policy, but if in fact it's not your policy to ensure that your subsidiary always fulfill their obligations, and this is kind of misrepresentation.
See, I don't think there's a tort there, because I don't think, like, there's nothing intentional. There's
Well,
no
intentional to
tort.
interfere with the contract, because obviously,
But I don't think there's an intentional interference there, and I'd argue there wouldn't be a negligence claim because arguably parent company does not owe a duty of care.
But if, because you made a statement, so this arguably this kind of presentation to the recipient. So if this statement is not true, then and the recipient puts reliance on the statement and entering the contract with your subsidiaries.
You're looking at it in a binary way, and I say this isn't a binary scenario. It is our policy. I take that as we like to cover our subsidiaries, but we don't always. So I don't think there's an untruth in that. I don't think there's anything, definitely nothing that can be sued upon in a tort. There's no deception, nothing like that. No intention to deceive.
Yeah, I think maybe like go to the bank, you have to co-sign for a son or a brother, sister. Try giving the bank a letter of comfort instead of a guarantee, right? They're not going to sign it. And that's the way I like to make my money, because at that point, I mean, you may in good faith want to guarantee or give a little comfort to support your son, your daughter, your brother, sister, but if financially things change with you, you're not bound by that contract. That's why I agree with you, like if the letters of comfort are just, you know, is that it? Just tries to give you some sort of comfort level, but, you know, if the bank's not going to accept that as a guarantee, then there'll be a commercial contract.
Yeah,
Accept that.
and going to the gentleman's point, that sometimes they are relied upon. I think the point from a contract perspective that we take here is you want to be careful with a letter of comfort coming across your desk and looking upon it as a binding document. That's something that you'll want to scrutinize. Yeah,
See, putting the letter of comfort aside, does that mean a parent company can be held, you know, responsible for the action of a subsidiary?
Theoretically, yes, but it depends on how things are arranged. And that kind of takes us into another area of law, like company law and the arrangements between the parent and the subsidiary. If it's done correctly, there should be no liability for a parent company.
Okay, because I was just thinking of the case of Chevron, and you know, is it Yaguadji or whatever? You know how Chevron was held. Chevron Canada was held liable for the subsidiary in Ecuador or one of those South Africa.
Was it a human rights issue?
It was about spillage.
Yeah, so environmental, human rights, sometimes that has happened. And courts will do something akin to piercing the corporate veil to say, well, ultimately you are the directing mind of this subsidiary. So in that case, but generally on the financial side, on the contract economic side, courts don't do that. Agreements in writing. If you did property law, you know about the statute of frauds. The modern version, we take the Sale of Goods Act, Section 6, the Alberta one, which is in your notes. Section 6, subsection 1B, that anything of value above $50 has to be made through a contract in writing. So the idea was that items of value, such as property, which is what the statute of frauds was dealing with, have to have something in writing behind it. So we can say, generally speaking, can you contract orally? Yes. A contract can be made orally. It's not wise. And generally speaking, there's legislation to say that where the subject matter of the contract is of a certain value, at least a certain value or more, there must be a written agreement. And I think the next and last portion is parole evidence. Is that what you have in your notes? Parole evidence we talked a bit about yesterday, and there are two versions of the rule that I've noted in the notes, borrowing from Professor McCandless's book, who is an emeritus professor here. The traditional rule is where a written agreement appears on its face to be a completed agreement. Parole evidence cannot be admitted that contradicts, varies, adds to, or subtracts from the terms of the written agreement. The modern rule places an emphasis on the need to demonstrate that the parties actually intended to reduce their agreement into writing as a precondition. Now, the idea of the parole evidence rule is, if we put it in a sort of contemporary, simple way, if you're selling your car to someone, and in the contract, it says this car is in good working order, but you give an oral assurance because it's summer in Toronto that the air conditioning works and it doesn't, can the person sue because the air conditioning doesn't work and you gave an oral promise? So you'd be looking to deal with the parole evidence. What do we get from the Harish decision? Harish versus Bank of Montreal. This was excerpted in the text. What happened here?
Yeah. So obviously, Harish signed an agreement, a guarantee provided by the bank for guaranteeing that the future employment of the indebtedness of the new company will be guaranteed, and later on, when the company became insolvent, the bank sued and put an action. And the court held that if the oral agreement somehow consistent with the written one, there is no problem. But if the oral agreement is contradicted with the written one, so it's unenforceable.
Okay, and what did it find here?
So the court found that the oral undertaking was inconsistent with the provision in the guarantee, stating that was a continuing, the bank could enforce the guarantee.
So the parole evidence rule is applied here. That the court says the contract was in writing only, and the purported oral variation was inconsistent with that contract. And that's similar to what we see in Bauer versus Bank of Montreal. What is different in the Evans case? Why was the outcome different here? J. Evans and Son versus Rosario.
Because the bank basically failed to register the sign. They failed to protect themselves in accordance with the contract.
In J. Evans? In J. Evans?
Oh, I'm sorry, I was looking at Bauer.
Why did the parole evidence rule not apply here?
Because I don't know. The 11.
Well, they couldn't rely upon clause 11. So if we applied the parole evidence rule, clause 11 could have been relied upon by the defendant, but the court said the defendant could not. Why was that? Why, in this case, do we not have that application, whereas in the other two, keeping in, I know they're in different jurisdictions, but what was the difference here in terms of how the contract was constructed?
Because the register of the signers was not properly done, right? So the whole thing is that there is a written contract and they are contradicting the oral one.
A bit more than that.
The written one has a default.
Right, but they didn't go with the written contract here.
Was it not thought to oral and partly written? That's what you thought highlighted. And is that perhaps the reason why?
Yeah, the court is saying this is not exclusively a written contract. The contract was formed in different ways, partly oral, partly in writing, partly by conduct. So in order for the parole evidence rule to apply, you have to have something, oftentimes you'll see in the contract, there's a clause that says, no oral variations are permitted. Or the entirety of the agreement is what is written and nothing that's stated otherwise is valid. That's basically what the parole evidence rule is saying. Only the written contract governs the relationship. But if you have contracted through a variety of means, arguably all the means you can contract through, oral, written, and conduct, then you cannot rely on the parole evidence rule and say, well, only the contract, written contract should apply. Because you didn't form the contract exclusively through the written form.
This was maybe an element of inducement here, because from the summary, it looks like a promise was made. I mean, I suppose the old part, but it seems the promise may induce the contract.
So that's what we get in the Galen case.
I have a question. So what you mentioned that it should be like mentioned in the contract that we have to rely on the written part and not like oral. We have to mention this part to be.
Well, you don't necessarily have to, because we saw in the Bauer case, for example, that I don't think they had that clause, but the arrangement was only done through the written agreement. The problem in the Evans case was the agreement between the parties was done through oral, written, and conduct. So the party trying to rely on the written agreement has a problem. They can't say parole evidence rule says only the written agreement, because there is enough evidence adduced for the court to be satisfied that that was not exclusively how the contract was arranged. So similarly in Galen, we have an oral assurance. That complicated matters with regards to the written agreement. So what we've looked at today, or if we sum up this week, we've gone through about 3/4 of formation of contract, offer acceptance and intention to create legal relations. We looked at how, on their face, each of those concepts, including certainty, are easily understandable, but sometimes when you get down to the details of things, it's much more complicated. And I think we outlined some of those complications. And we also did a couple of problem questions to delve into those issues, simulating not just what an exam can be like, but also how you think through questions for the purposes of exam. And I hope also that can be applicable for practice in comedy.
Was that sample question, sorry, from that case, the counter case?
Yeah.
Is that also the short question?
Oh, yeah. That could be, so in Canada, in the US, problem questions on exams can be like 3 pages long and have multiple issues. Whereas I found in the UK and Europe, at least, you have one question and one issue. We don't do that here. So you could have that clause and that could be one issue, but it wouldn't be the entirety of a question. So next week we pick up with consideration, which is a kind of a complicated topic. Yeah, next week we kind of get into more complicated topic. So I hope you have a good weekend.